Let's see, which one of these do we want to call? DED 130, 130.
Oh, you want to do the video first, Judge? Yeah.
Yep, there it is. All right, are you Ralph Morrison?
Yes, sir.
All right, this case number 21-CR-186, State of Ohio versus Ralph S. Morrison. Mr. Morrison is appearing by video at the Justice Center. His attorney is Jacob Wagner. He is present actually in the courtroom, and also present is the prosecuting attorney, Lieutenant Collins. Defendant is charged with failure to comply to order signal of a police officer, third-degree felony, and receiving stolen property, fourth-degree felony. This is a hearing on the results of the examinations that were ordered by the court of Mr. Morrison's mental status. I received a report from Dr. Carla, spelled C-A-R-L-A-S, Dreyer, D-R-E-Y-E-R, psychologist, dated 12/21 of 2021. And in her opinion, the defendant is currently capable of understanding the nature of objective proceedings and is capable of assisting counsel. And then he is competent to stand trial, and he should be abstained from using any substance abuse to maintain his competency. All right, now each of the attorneys received a copy of this report.
Yes, Your Honor.
I have, sir.
All right, and either of the attorneys wishing to provide any other evidence on this issue?
The state is not, Your Honor.
Your Honor, defense counsel and I had the opportunity to actually personally speak with Dr. Dreyer. That's what she did, fill me in on any questions I didn't have, so no further information.
Okay. All right, well, the defendant then is found competent to stand trial based upon the report of Dr. Dreyer. The matter will be restored to the active docket. Set a, we have one pre-trial on this already, I believe, haven't we?
I don't believe so.
We haven't. All right, let's see where we're at then. I say first pre-trial is supposed to be December the 1st, but I believe that might have been maybe out of order for that. All right, so we'll go ahead and set a first pre-trial for January the 19th. Final pre-trial will be January the 26th. Both those will be at 1 p.m. by Zoom. And then trial date will be set for February the 7th at 8 a.m. And speedy trial is told until that date due to the need to have the evaluated. Now, are there any other matters that need to be discussed at this time?
Not the state, Your Honor.
Defense counsel.
All right. We'll be seeing you then in a couple of weeks, Mr. Morrison, for your first pre-trial. Your attorney may address.
You ask Mr. Wagner to come out and speak, please, sir?
Is there one now?
Could you ask Mr. Wagner to come out and speak to me, please?
Who, your attorney?
Yes, sir.
Yeah, he'll contact you. Yeah. Okay. Thank you. All right. Mr. Morrison is going to be by video, it says.
That was that. If I may address the
Well,
question.
I'm not Morrison. Ray, is he around?
Melvin is, yes, he's with his father. They're in the.
All right, let's go ahead and get him. All right. Then we'll call Mr. Phil.
so, then I'm gonna have you come around this corner here and have you sit there. Sir, if you just want to grab one of the seats there, you're more than welcome.
All right, case number 21 CR 52, State of Ohio versus Melvin D. Gray II. Present with the state's prosecuting attorney Collin, present with the defense attorney Jacob Wagner, and you are Melvin Keith Gray II. All right, Mr. Ray is charged with felonious assault. He was previously found not competent to stand trial and was referred to Twin Valley for outpatient competency restoration treatment. The court received the 6-month report dated 12/21, and the report evaluation of the report dated the same day from Dennis M. Eschball, ESHBAUGH, PhD, clinical forensic psychologist from Twin Valley, in which he stated that the defendant does have a serious mental illness. He continues to experience substantial residual symptoms, although he's not acutely psychotic. He's not currently capable of understanding the nature and objective of proceedings or assisting his defense, but it is opinion that is more likely than not that he can be restored within the time allowed by law. Has improved since he's been in treatment with Dr. Leatherwood, and has made gains in his education, and his recommendation that the defendant be continued outpatient restoration treatment pending further report in the next 6 months as to his ability to be restored. Now, have each of the attorneys received a copy of that report?
The state has none.
We have, sir.
All right, any other evidence to be presented by either party?
No, Your Honor.
No, Your Honor.
All right, then it's order of the court, Mr. Ray, that you continue with your treatment at Twin Valley in the outpatient clinic and comply with their recommendations, and that will be continuing for purposes of restoring you to competency, what we call legal competency for purposes of court proceeding. And they'll be required to provide a further report in 6 months. All right. And are you still reporting the probation?
No, sir.
Okay. Well, I do want to report the probation, so go ahead and go down there today. And I'm going to tell them to put you on every 2 weeks or so, just to check in with them, so they know where you're at, keep track, and make sure you're going to your treatment. Okay?
Your Honor, may I confer with his father? Just-
Yeah, absolutely.
So, Judge. Just part of probation, we give you Just go down there and check on it.
So did Jason get over her COVID? Did she have it very bad? That's it.
So she, Delana had it worse.
I knew she had it bad. All right, so you feel more.
Okay, Judge.
State of Ohio versus Roger Allen Fillmore, case number 21-0156, President of the State is Prosecutor Attorney Collins, present for defendant is Attorney Jacob Wagner. Defendant is not present, he is charged with receiving stolen property as a fifth-degree felony. Wagner, have you heard anything from Mr. Fillmore recently?
Yes, sir, if I may, just from a time when cover my tail. I've been gone, all last week in Maryland. Had my secretary start calling him to schedule this to get him in. The number we had kept getting no service, no service, no service. I began calling it over the weekend. I tried to get him in yesterday to go over the plea forms, get ready to sign. Tried again this morning, about 8:15, he called my office from a different number. I personally spoke to him, asked him where the heck he'd been. He informed me his cell phone no longer had service. That's why he was calling from the 365 number. 365-5021 was the number he called me from. I told him to get a ride to get here. He had just called my office about 8:55. My secretary texted me, indicated he did not have a ride, he would not be appearing. I told him to call him back, tell him to get here, my day is free, so I will be here waiting for him. This is where I stand.
Okay. Well, the defendant hasn't reported probation since the 21st of December after testing positive on the 16th, 17th, and 20th for various substances. He failed to appear on the 22nd and 27th as called in. He was put on the call-in drug testing system and failed to call in after the 22nd. And he has a warrant from municipal court for failure to appear on the 27th. So the court will order, and also there was someone who called here this morning wanted to know if his hearing would be by Zoom or in person, and we'll give him for that. I think it was a female, maybe somebody that would be his mother. Anyway, we told them that he would be required to be here, and that was about 8:15. So, in any event, the court will find that he has failed to appear, papers will issue for his arrest, and the matter will be placed on the inactive docket until he is brought before the court. Thank you.
Yes, sir.
All right, we're in the Rose case now. Thank you, Lieutenant. Thank you.
I was there. Yeah, I don't think. Yeah, we signed it all out.
Oh, yeah.
Yeah, we did it the other day.
All right, it's case number 22 CR 001. State of Ohio versus Amy Michelle Rhodes. Attorney on behalf of the state, prosecuting attorney Colin, on behalf of the defense attorney David Wagner. And you are Amy Michelle Rhodes?
Yes, sir.
All right, this matter is before the court for a plea on a bill of information. And have the paperwork here. Now, Ms. Rhodes, under Ohio law, no one is required to come before this court to face a felony charge until and unless that person's case has been submitted to the grand jury of the county and the grand jury's returned indictment. The grand jury is composed of 9 people that are citizens of this county that are selected to serve, usually for a quarter, 3 months. And they meet usually once a month, and they hear evidence is presented to them by the prosecutor's office regarding an alleged crime. Now, the grand jury doesn't determine whether the person is guilty or not guilty. They simply determine whether there's sufficient evidence to justify the case moving forward. So it only takes 7 of those 9 votes to vote in favor of an indictment for indictment to be returned, whereas in a jury trial it requires 12 people to be unanimous. And so if 7 of the 9, after hearing the evidence submitted to them, determine that there's sufficient evidence that the case should be, indictment should be returned, the person brought before the court, then that person is indicted. And the indictment then is a document that sets forth what the charge is. Now, that has not happened in your case yet. The grand jury is scheduled to meet tomorrow, for the first time, the new grand jury. The last one ended their service the first week of December. And so right now you're not facing any charge. Now, you are permitted under the law, however, to waive or give up that right. And what that means is that you would agree that instead of having your case submitted to the grand jury and evidence submitted to them to consider, that you would agree to allow the case to come before this court on what's called a bill of information. A bill of information is essentially the same as a bill of indictment, except that it's not been voted on by the grand jury and signed by the foreperson of the grand jury. Instead, it's simply signed by the prosecutor or one of her assistants, and it sets forth what the charge is. And so I have that bill of information proposed here that says that beginning on or about the period of January 1, 2021, continuing through November 1, 2021 in Huntington County, Ohio, you did with purpose to deprive the owner of the Huntington County Humane Society of their property, and obtain or exert control over said property to wit U.S. currency in the amount of $5,900 and other miscellaneous items, said property being equal to or exceeding $1,000 but less than $7,500, without the consent of the Huntington County Humane Society and the owner or person authorized to give consent, in violation of Ohio Revised Code Section 2913.02A1, theft, a felony of the 5th degree. So that is the charge, and that is the proposal that you go forward here today. Now, I have also designated as a waiver of prosecution by indictment. It has your case number and your name on it. And it says that I, Amy Michelle Rhodes, having been informed by the court of all my constitutional rights and the right to be prosecuted by way of indictment, being represented by J.D. Wagner, attorney at law of Hillsborough, Ohio, do hereby freely and voluntarily waive prosecution by indictment and agree to proceed in this manner by bill of information. Stated 12/20/21. I see Mr. Wagner's signature, and there's a signature line immediately below that that says defendant. And is that your signature I'm looking at?
Yes, sir.
Right. And you did sign this document on the 20th.
Yes, sir.
And you had your copy of the bill of information back on the 20th as well.
Yes, sir.
Okay. Now, by signing that document, you're saying that you're going to waive the right to have your case presented to the grand jury and agree for it to come before the court on the bill of information. You understand that?
Yes, sir.
Okay. Now, the next step then in the process would be to enter a plea. Now, typically when somebody's indicted, they're brought before the court and enter a plea of not guilty. If they have an attorney, and if they don't have an attorney, court enters one form and appoints them to represent them. And then there are certain matters that are done before the case comes before the court for trial. There are pre-trials, or what's called discovery, where the defense asked for information from the state about statements, evidence, reports, names and addresses of witnesses, if they have any criminal records, any information that the state has that's relevant to the case. Now, that hasn't happened, but do you feel that your attorney has had enough time to talk with the state and to analyze the situation to properly represent you without going through that process?
Yes, sir.
So you're comfortable going ahead and moving forward here today?
Yes, sir.
Well, then I have a plea of guilty form, and it is a 3-page form that the prosecutor's office prepares from a template in the computer, and has your case number on it, and it actually says whether or not we'll start that. And it basically says you're going to enter a plea of guilty to the charge I just read you of theft, the 5th-degree felony. Now, on page 3, there are signature lines, and on halfway down the page, there's a sentence that says, I enter this plea voluntarily, and immediately below that, there's a signature line, and signature of the defendant, little X, and I see Mr. Wagner's signature, this is the King's signature of the prosecutor's office. Did you sign this document?
Yes, sir.
You signed it also on the form that was sent?
Yes, sir.
Right. Now, you understood when you signed this, it was an agreement to plead guilty, which means there won't be a trial. And you discussed this matter with your attorney before you signed it?
Yes, sir.
He explained everything to you?
Yes.
Do you feel you had enough time to fully consider this matter before making this decision?
Yes, sir.
And are you entering into the agreement with the state to plead guilty voluntarily?
Yes, sir.
Okay. Now, what this agreement says is that you understand that the charge to be pleaded guilty to is theft under 2913.02A1 of the felony. Further understands that if you are convicted and sentenced to that offense, there could be a maximum prison term of 12 months, minimum of 6 months if it warrants prison term. Could be a fine of $2,500. You understand that?
Yes, sir.
Are you facing any felony charges in any other jurisdiction?
No, sir.
Are you on felony probation, community control, parole, or post-release control from any jurisdiction?
No, sir.
Now, if a person is convicted of this offense and sentenced to prison, under the law, the adult parole authority, upon completion of that prison term, to put that person in what's called post-release control supervision for a period of up to 2 years, which means that you would be supervised if that occurred by a parole officer in the term set by the parole authority, because the judge has nothing to do with that. And if they determine during that period of time that you failed to comply, they could return you to prison to make you serve an additional period, even though you served the entire term set by the court, for a maximum period in this case of up to 1/2 of your prison term, whatever prison term was imposed for one or more violations. But if a new felony offense is committed while under post-release control supervision, then in addition, whatever sentence could be imposed by the judge in that new case, that judge could also sentence you for committing that felony while under post-release control supervision to an additional period of 1 year, or whatever time is left on that 3 years or 2 years of post-release control, whichever is greater. That occurred, that would be served consecutively the sentence in the new case. You understand that?
Yes, sir.
Now, under the law, if you're convicted of this offense, the court's not required to impose a prison sentence. Instead, it can impose what's called community control or non-prison sanctions, which means that instead of being put into a prison, you would be put under the supervision of the probation department for a period of up to 5 years under the terms set by the court. And if during that period of time that you're being supervised, the probation department felt that you were not in compliance, then they would file a written notice of that to the court, serve a copy on you. There would be a hearing. You would be entitled to have an attorney to represent you at that hearing. If the outcome of the hearing was that you failed to comply, then at that time the court would revoke your community control and then sentence you to prison for 6 to 12 months, fine you $2,500. You understand that?
Yes, sir.
All right, now, I just read the bill of information to you a few minutes ago. You're familiar with that?
Yes, sir.
All right. You understand what it is the state's accusing you of having done, when, where, and how they allege you did it?
Yes, sir.
And have you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, the possible defenses you can try to raise at trial, the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and comments in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any type of prescription drugs?
No, sir.
Have any threats been made against you to plead guilty here today?
No, sir.
Now, on page 2, there are 4 lines that are printed and underlined, and I'll read those. Those are the key parts of this agreement. Defendant shall enter a plea of guilty to the bill of information. Prosecuting attorney recommends defendant be placed in Huntington County Prosecuting Attorney's conversion program. Defendant agrees to make restitution in the amount of $5,900 to Huntington County Bank Society. Now, is that your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that in case you plead guilty here today?
No, sir.
And as soon as she's been in and signed her contract, paid the fee.
She still owes $50 in the fee.
I paid that this morning.
All right. Now, the diversion program is somewhat, it's a different procedure than the typical case in which a person is pleads guilty or is found guilty after a trial. Normally, if someone pleads guilty or is found guilty after a trial, then that person is then sentenced. Could be, as I mentioned, prison, a fine, or community control, or some combination. Once that decision, the sentence is made, that person then has a conviction. It's a felony conviction. Now, there is a provision under the law, which is being proposed in this case, that you plead guilty, but that instead of being found guilty, the court stays the proceedings. The stay means to stop or freeze, pending a report from the prosecutor as to your compliance with a diversion contract. And so you've signed an agreement with the prosecutor. You understand what it is you're required to do.
Yes, sir.
Okay. And so what happens is the court then would not find you guilty. And so even though the files of the court would reflect that you have pled guilty, it also reflect that the case has been stayed. There is no finding of guilt, and you're not convicted, even though you pled guilty. And so if anyone asks you, you say, no, I'm in diversion, I'm not a felon. If you complete the obligations under the agreement with the prosecutor, then they report that to the court, and the case is dismissed. And so even though you pled guilty, you're never found guilty. And once that occurs, the court dismisses the case, and it also then says we're hearing a sealed record, and it will, unless something happens between that date and the date of the hearing, then the record is sealed. And then it's removed from the court files, removed from any law enforcement files and databases, and it's then no one can look at it or find it except in certain limited circumstances, like if there was another felony charge in the future, the probation and the prosecutor's office can look at it as well as the court, but very limited circumstances. And so that's the difference between typical guilty finding and what diversion means. So do you understand that?
Yes, sir.
Okay. Now, also, the right of diversion, or there isn't a right to diversion, is basically the prosecutor's discretion to accept somebody into the program which they have, but they're also the ones who will determine whether or not you're compliant. And if they determine that you're not compliant, then they report that to the court, and then the court will terminate you from the program. They don't have to prove that you've done something intentionally or committed any crime, whether it's just that you're not compliant. So they have a fair amount of discretion to do it. But if that occurs, then you're brought back to the court, and the court then terminates the diversion, finds you guilty, and then at that point would impose a sentence. And if that occurs, then at that point you would have a felony record. And again, that could be, like I said, community control or prison time or a fine or any combination thereof. You understand that?
Yes, sir.
Well, because the program provides that you're going to plead guilty in order to be put into the diversion program, this is your last chance to stand on your not guilty plea and contest the charge. So therefore, you have to be aware of what rights you're giving up before I accept the plea. First, you have a right to have counsel. Mr. Wagner, you employed Mr. Wagner, right? And so, in the event that you didn't have the funds to hire an attorney to represent you, if you were charged in this case, the court would appoint one for you at no cost. So you understand that?
Yes, sir.
So you're not entering a plea guilty here because you're worried about not being able to pay an attorney.
Yes, sir.
Okay. Now, under the Constitution, you have a right to have a jury trial in this matter, Ms. Rose, in which 12 people would be selected from a group of citizens that live in this county that are subject for jury duty on your trial day. After those 12 are selected, the evidence will be presented, they'd be instructed on the law, then they will decide by unanimous verdict, meaning all 12 have to agree as to whether or not the state proves your guilt. of the charge. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, and as you know from the waiver of prosecution by that, the waiver needs to give up, in writing, in this case, the right to have a jury trial. And in that case, in that situation, then you would have this called a court bench trial, meaning that instead of a jury hearing the evidence, the judge would be the one who hears the evidence, the judge would apply the law, and the judge would decide whether or not to state proof of guilt, proof beyond a proof of that. You understand that?
Yes, sir.
Right now, in the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney. So what that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney has the right to ask questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that will help your side of the case. You understand that?
Yes, sir.
And Ms. Rhodes, under the Constitution, you have a right to confront witnesses against you and cross-examine them through your attorney in open court. What that means is the witnesses would have to come into the court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney will ask questions. It's called cross-examination. The purpose of that is to give us to bring out evidence to help your side of the case. Do you understand that?
Yes, sir.
And under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain going to come in voluntarily, your request for issues court order is called a subpoena. That forces those people to come to court to testify for you if you want them to, if they don't want to be here, which is the same way the state witnesses are required to come to court. Do you understand that?
Yes, sir.
Ms. Rose, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this case at any time, including the trial. No one can ever make you testify. The prosecutor can, the judge can, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one is even allowed to talk about it except in one situation, which is if there's a jury trial and you did not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, Ms. Rhodes, you're presumed innocent until proved guilty by the state of Ohio on every essential element of the offense charged. What that means is that the burden of proof is on you to try to prove you're not guilty if you're accused of a crime. In fact, under the law, you're not required to present any evidence at all in your own defense at a trial. You may, but you're not required to. But whether you present any evidence in your own defense or not, the burden of proof will always remain upon the state to prove your guilt by proof beyond a reasonable doubt in every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, you could enter a plea of not guilty, because this is basically your arraignment. And a not guilty plea would deny the allegations in the charge and the bill of information, deny you committed any crime. That plea would exercise all the rights that I just described. Now, if you change your plea, if you enter a plea of guilty, which is opposite of not guilty, that plea admits the allegations, admits that they're a crime, and that you committed that crime. And that plea would waive and give up all the rights I have described for you this morning, except the right to have counsel, because you always have the right to have counsel no matter what you plead. But with that exception, your plea of guilty waives gives up the right to have a jury or court trial. Waives gives up the right to confront witnesses against you and to cross-examine them through your attorney. Waives gives up the right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. Waives gives up your privilege against self-incrimination, because if you say you're guilty, that's what you find you guilty. Waives gives up your presumption of innocence, because if you say you're guilty, the state's not required to prove that you're guilty. Now, it also will subject you to being sentenced immediately by the court if the court proceeded to do that. And it will waive and give up any right to file an appeal that you think you may have had up until this point in the case. Now, you should be sentenced to a maximum sentence, or under certain circumstances, you can file an appeal. And after you file within 30 days of your entry of conviction being filed. You understand that?
Yes, sir.
Now, are you a U.S. citizen, Ms. Rose?
Yes.
Okay. And you're entering into this agreement voluntarily.
Yes, sir.
Now, do you have any questions about the waiver of indictment and the prosecution of bill of information to process across you here today?
No, sir.
You understand?
Yes, sir.
Any questions about the charge and possible penalties?
No, sir.
You understand?
Yes, sir.
Have any questions about the diversion process or how that works or what's going to be required of you to comply with that.
Yes, sir.
You understand that?
Yes, sir.
Any questions about the constitutional rights of the plaintiff?
Yes, sir.
You understand it?
Yes, sir.
Any questions about the plea of guilty, what that means, and what the consequences of that would be for entering here today?
No.
You understand that? Is there anything you'd like to speak to your attorney about before we go any further?
Yes, sir.
Do you have any questions about anything that I've covered here today?
Yes, sir.
All right, then, is it your decision to withdraw your not guilty plea and plead guilty to the charge set forth in the bill of information? Pursuant to this agreement that we just gone over.
Yes, sir.
All right, then as to the charge, in the bill of indictment or information that reads that on or about the period of January 1, 2021, continuing through November 1, 2021, in Highland County, Ohio, that you did with purpose to deprive the owner of the Highland County Humane Society of their property, knowing obtain and exert control over said property, to wit, U.S. currency in the amount of $5,900 and other miscellaneous items, said amount being equal to or exceeding $1,000 or less than $7,500, without the consent of the Highland County Humane Society, the owner person authorized to give consent, violation of the Ohio Revised Code section 2913.02A1, theft, a felony of 5th degree, carrying a possible prison term between 6 and 12 months, and fine of $2,500. How do you plead?
Guilty, Your Honor.
Thank you. Receive. All right. The court will find that on this date, the court defendants applied all the constitutional rights made known until the voluntary waiver of the same pursuant to Rule 11. That plea is accepted and ordered filed. Now, the court finds that the defendant has entered into a conversion agreement, and the victim, as well as the investigating officer, were notified of this and agreed with this.
Yes, Your Honor, actually clear back on November the 23rd. I spoke with several members of the Humane Society Board as well as detectives Angela and Eve when they all agreed to this as well as the amount of restitution.
Okay. All right. The court will also find then that the defendant has entered or has filed an executed waiver of time under 2935-36 for this proceeding. Also signed on December 20th. Anything further than counsel?
Yes, sir.
All right. The court then finds that the defendant is eligible to participate in the Highland County Prosecuting Attorney Conversion Program in accordance with the standards for that program that have been adopted by the court, and will grant the defendant's request for admission to that program, find that she has entered into an agreement and has made arrangements to pay the participation fee. It's therefore ordered that the defendant's guilty plea be held in abeyance and the matter stay pending report from the prosecuting attorney's office regarding her progress in the program. The defendant is ordered to pay the court costs as well as the restitution that is provided for in the agreement. All right. Now, also, the court will notify counsel that given Ms. Rose's employment at the probation department, that Mr. Brady informed me that the probation officer in Fayette County and her out of town now has agreed to do the supervision. And so when you get done here, you'll need to go down and see Mr. Brady, and then he'll contact that officer and make arrangements for you to be reporting to him. All right, is there anything further, counsel?
No, Your Honor.
All right, thank you.